Great, thank you. So again, my name is Margaret Shamu. Welcome to 19V. And I am joining you from the New Schools Parsons School of Design. And today's speaker is Jonas Visholik from Queen's College, Cambridge. He'll be speaking on international law and colonial violence, Russia's campaigns in Central Asia, 1870s to 1880s. And our собеседник today will be Svetlana Gorshenina from the CNRS in Paris, the Centre National de la Recherche Scientifique. So please, Jonas.
Thank you very much. Let me just start the presentation. I hope everybody can see the slides and hopefully also in full screen mode. If not, just let me know now or later during the talk if there are any technical issues. First of all, many thanks to the conveners for giving me the opportunity to speak in this wonderful seminar series, which gives scholars from diverse disciplinary and regional backgrounds the chance to discuss the fascinating 19. wiek. Thanks also to the student staff for making the technical aspects of this meeting work out. And finally, many thanks to Svetlana Gorshenina for agreeing to act as a discussant. I'm very excited to hear your comments later on, and also about the general discussion we will have after the talk. Today, I will present a paper based on a chapter of my PhD research in which I examine the role of international law in the conquest of Central Asia. The paper, titled International Law and Colonial Violence, Russia's Campaigns in Central Asia, will explore how progressive developments in international law relate to Russia's military campaigns in Central Asia in the 1870s and the 1880s. I would like to use this depiction of Prince Yevgeny fighting against Turkmen in 1873 to introduce a major theme that we will explore in the next 40 minutes or so. We see a strong metaphorical opposition at work here. The bright civilization-bearing Russian aristocrat with modern firearms and in military uniform is contrasted to the backward, traditionally dressed Yomut enemies emerging from the dark background.
Jonas, I'm sorry, it's Margaret interrupting. We don't see a new slide. We see your title slide.
Okay, that's not how things should be. Let me just see if I can fix that quickly. Does it flip now?
No.
It's not changing. You might need to stop share and reshare and just make sure that you selected the correct screen.
For pointing that out, that is quite essential. So let's go for this window. How about now?
It hasn't shown up yet. Yes, now we see the slide that you're discussing.
Perfectly. Okay. Exactly. So I was about, as I just said, we see a strong metaphorical opposition here at work. The bright civilization-bearing Russian aristocrat Prince Yevgeny fighting the Yomut Turkmens, dark in the background in traditional dress. And with this metaphor of light and darkness in mind, let's dive right into the topic. My paper takes its cue from the following tension. To this day, Russia is held in high esteem for its contributions to international law in the second half of the 19th century. Strikingly, the same period featured the most violent episodes of the conquest of Central Asia. The question arises how Russia managed to reconcile the promotion of international law with the use of excessive violence in its colonial endeavors. My claim, or perhaps hypothesis, in response to this question is that Russian lawyers and diplomats managed to limit the criticism of Russian military action in Central Asia by stipulating a disjunction between the European laws of war on the one hand and colonial warfare in peripheries like Central Asia on the other hand. Two developments supported this disjunction. First, in Europe, Russia promoted the codification of the laws of war to foster its image as a progressive power. Second, in their promotion of international law, Russian diplomats and lawyers advocated rules that exempted violence against non-European actors from legal regulation. By opposing Russia as a peaceful, civilizing power to the barbaric polities of Central Asia, they laid claim to the prestige of a promoter of international law in Europe, while simultaneously rejecting legal restraints on Russia's military conduct in Central Asia. This deeply ingrained disjunction between European laws of war and colonial warfare allowed Russia to reconcile two developments that may appear contradictory at first sight: championing the cause of humanitarianism in Europe and simultaneously using excessive violence in Central Asia. The paper proceeds in three steps. First, I will examine Russia's promotion of the laws of war in Europe to illustrate how the Tsarist Empire used international law to bolster its image as a civilized and progressive power. Second, I will analyze the doctrines promoted by Russian legal scholars for assessing violence from the point of view of international law. Third, and finally, we will have a closer look at two concrete episodes of the Russian conquest and their coverage from the point of view of international law. Throughout the presentation, I will use prints, photographs, and paintings to highlight certain aspects of the paper, like the one of Prince Yevgeny we started out with. I should emphasize or confess, though, that I do not pretend on a systematic analysis here. I hope the art historians can forgive me for merely using these illustrations as illustrations, nothing more. Let's move on. I hope the slides move along as well. If not, please let me know. These photographs show Fyodor Martens, Russia's most influential international lawyer of the second half.
Jonas, I'm afraid that we don't have a new slide.
Let's see if we I'm gonna do it from the start and hope that
Yes.
this time. And let's try it out this time before I start talking. That should be more efficient. Okay. Okay, so we're back, and does it move on?
So now we have the whole the whole slideshow, but we don't have the full screen. You're not in full screen mode.
Okay.
Yes, now you're in
Okay,
full
there
screen
we
mode.
go.
Beautiful. Okay,
Can
so
you try flipping between the slides?
Yes, and just give me a second. Does it move along?
now
So
you're back
now
in.
we're seeing PowerPoint.
Okay, I think there seems to be a certain delay because I'm back in full screen mode.
We don't see full screen mode.
Okay. Let's see.
Okay.
Now we see. Yes, now you're flipping.
Great.
Perfect.
Great.
Yeah, so sorry about that. All right. These photographs show Fyodor Martens, Russia's most influential lawyer of the 19th century. His bust in the Palace of Peace in The Hague, which houses the International Court of Justice and the Permanent Court of Arbitration, testifies to the lasting prestige flowing from Russia's contributions to international law. So, as a first step, let us review how Russia promoted the regulation of warfare in Europe. Martens was well aware of the relevance of the laws of war to gain civilizational prestige. Summarizing a widely shared view in 1899, Martens presented war as the ultimate challenge for the law's civilizing ability. Quote, "War is a state of unlimited arbitrariness and the most horrible violence. If legal restraints were respected in the heat of the battlefield, then international law could be trusted to exert a pacifying effect on international relations more broadly." In Martin's understanding, the laws of war were underpinned by a firm belief in the triumph of international law, facilitated by the progress of human civilization. Quote, "With the development of culture and civilization, with the respect for the individual, his personal freedom, aspirations, feelings, and rights, the field of international relations and warfare is little by little subjected to certain rules and order." The laws of war served as a litmus test for the belief in the law's civilizing ability among what Martti Koskiniemi described as the men of 1873, a generation of lawyers, politicians, and diplomats who dedicated their lives to the development and strengthening of international law. Since, to quote Martens again, war is an expression of the moral and mental development of the belligerent people, the stakes were high for Russia's ambition to use international law to buttress its civilizational status. The accounts in the historiography converge when it comes to Russia's preeminent role in the development of the laws of war. These achievements have long served, as Lori Marxo put it, a source of pride in Russian scholarly debates on international law. But there remains controversy as to why the Tsarist Empire supported international law. Michael Riepel, for example, lists idealistic, diplomatic, economic, and strategic motives united by, in his words, Russian ingenuity. By placing these developments in the context of Russia's colonial expansion, I would like to suggest, by contrast, that international law allowed Russia to promote its image as a civilized power while simultaneously exempting the conquest of extra-European territories like Central Asia from legal scrutiny. To this end, Russia promoted a progressive, but ultimately Eurocentric understanding of the laws of war. In 1868, upon Russian initiative, the representatives of 21 states gathered in St. Petersburg and agreed to ban explosive projectiles causing excessive harm to soldiers. Hailed as a highly humanitarian project by Fyodor Martens, the St. Petersburg Declaration indeed amounted to one of the first multilateral treaties on the laws of war. Yet the Ottoman Empire and Persia were the only non-European states to participate in the conference. No Central Asian power was invited, although Russia was actively involved in warfare in the region. Since the declaration banned explosive projectiles only for war among the contracting parties, non-European conflicts remained basically unrestricted. In other words, Russia's contribution to the banning of excessively damaging projectiles benefited predominantly European soldiers, but not its Central Asian opponents. In 1874, the representatives of 15 states gathered in Brussels to discuss the codification of the laws of war on the personal initiative of Tsar Alexander II. Although never ratified, the Brussels Declaration represented the first comprehensive code of the laws of war. This time, the Ottoman Empire was the only non-European state to participate. Yet the exclusionary effect of the Brussels Declaration cuts even deeper, because it stipulated that the laws of war apply only to state-sponsored armies. The declaration endorsed the open battle between state-sponsored armies, that is, a predominantly European style of warfare, as the only legitimate form of violence from the point of view of international law. For Martens, the Brussels Declaration contained rules, quote, for armies of civilized nations. Conversely, the declaration dismissed other forms of resistance common in non-European cultures of violence as inherently illegitimate. Thus, to the detriment of non-European actors, the Brussels Declaration established that the laws of war did not apply to conflicts outside of the civilized nations of Europe. In 1898, Tsar Alexander III called for an international conference to ensure, quote, to all peoples the benefits of a real and durable peace. The subsequent Hague conferences of 1899 and 1907 perpetuated this Eurocentric understanding of the laws of war by treating conflict among state armies as the only legitimate form of violence. At the conference, Russia's representatives pushed for such a narrow understanding. The Hague Conventions were again restricted to war between two or more of the contracting parties. As a result, the humanizing effect of Russia's contributions to the Hague Conventions did not extend to the non-European peripheries. To sum up, Russia's enhancement of the laws of war placed the country squarely among Europe's most progressive and civilized powers, but it did little to limit the use of violence in Central Asia. It is hard to overstate the effect of Russia's promotion of the laws of war on its image in Europe. Tsar Alexander III, for example, was hailed as a humanitarian visionary by the peace movement. Yet non-European actors did not benefit from the legal regulation of violence promoted by Russia, and the conquest of Central Asia proceeded in the very decades when Russian diplomacy promoted international law in Europe. Before we turn to the actual military conduct, let us examine how Russian scholars discussed and theorized the justification of violence under international law. And now I hope it works well for everyone. Great. I'm on thin ice here since there are much more qualified people in the room to speak about Vereshchagin's Turkestan series, but for my limited purposes, I think this painting illustrates very nicely what the laws of war boil down to in the end. An effort of the warring parties to communicate despite the heat of the conflict and to agree upon certain minimal standards for the conduct of hostilities. Let us have a look how Russian scholars assess the prospects of such a dialogue between Russia and Central Asia. Russian scholars of international hailed their country's humanitarian achievements in Europe, but paid little attention to the conduct of the Russian army in Central Asia. This lack of scrutiny was underpinned by legal doctrines and theories that excluded non-European enemies from the scope of the laws of war. Working in lockstep with their Western peers, Russian scholars disseminated such Eurocentric understandings within the Russian state, army, and society. Fyodor Martens, aside from the leading role at the above-mentioned international conferences, wielded real political influence as a member of the Imperial Council of the Ministry of Foreign Affairs, where he discussed foreign policy with high-ranking statesmen. For Martens, the laws of war applied only to civilized nations. Quote, "It is only in relation to civilized states that there can be talk of laws and rules which must be observed during international conflicts. It cannot be expected and would be unjust to demand compliance with any legal norms from peoples of substantially different civilization and culture." Nikolai Korkunov, a colleague of Martens at the University of St. Petersburg, is of special interest in our context because he lectured at the Alexander Military Law Academy. After teaching international law to military officers for several years, he published a textbook in 1886, which gives us a sense of how Russia's military men encountered the laws of war. Korkunov argued that only violence among, quote, "members of the European International Union is relevant for the laws of war. Otherwise, these rules of war established in this union are not obligatory." As Frédéric Maigret has argued, the laws of war acknowledged the right to wage war in principle by outlawing certain other forms of military conduct. Yet, this right to wage war was reserved to states that met the threshold of fully independent and civilized statehood. As Martens put it, quote, "Such a right, the right to wage war, belongs neither to semi-independent states nor to uncivilized nations. The former cannot, in principle, enter into war on their own. The latter do not recognize any obligations." International lawyers classified the Khanate of Central Asia, so the Central Asian states, as such semi-independent states, and the nomadic tribes of the region as completely uncivilized. As a result, from the perspective of international law, Central Asian actors could not invoke the right to wage war, which also stripped them of the protection of the law during conflict. Consequently, Central Asian resistance would invariably be understood as criminal violence, lacking the legitimacy of a war approved and endorsed by international law. This exclusion ushered in potentially serious consequences on the battlefield. As Korkunov explained, a surrendered enemy was normally protected by international law. However, he restricted the right to be taken prisoner to, quote, "every open and lawful enemy." Conversely, this implied that the illegitimate non-European enemies constituted legitimate targets even after surrendering. Similarly, the list of prohibited means of warfare, like the projectiles causing excessive harm, depended for Martens on, quote, "the degree of cultural development and moral consciousness of the warring peoples." Excessive means of warfare that were banned in Europe could still be used against non-European enemies. With these deliberations of Russian legal scholars in mind, let us finally turn to the actual conduct in Central Asia. In this section, we will examine whether international law, as it was discussed by diplomats at the conferences and set up by scholars in the textbooks, played any role for Russia's military men on the ground, like the ones we see here on a page from the Turkestansky album. In the discussions of the military conduct by lawyers, diplomats, and journalists, we see the disjunction between the European laws of war and the military conduct in the periphery at work. I will first say a few words about the relationship between Russia's military men on the ground and the legal, political, and diplomatic elites in St. Petersburg. Then I will present two case studies of particularly violent episodes of the conquest. To a large extent, the laws of war were based on customs and examples from previous state practice. Any course of action supported by a sufficient number of states could give rise to binding customary international law. To a certain extent, it was the practice of states that defined the content of the law rather than the other way around. Thus, Russia's military men shaped the laws of war rather than merely following them. Their actions amounted to a certain state practice that could emerge as binding customary international law, provided the support of other states. When Russia deemed the laws of war inapplicable vis-à-vis non-European actors, they could point to the state practice of the Russian army in Central Asia. Thus, Russia's military corroborated the disjunction between Central Asian warfare and European laws of war, which was formulated in theoretical terms by scholars and diplomats. A division between European and extra-European warfare was facilitated by the fact that a distinct group of officers conducted the operations in Central Asia. Alex Marshall has argued that the military service in the Caucasus and Central Asia represented a distinct career path in the second half of the 19th century. The professional identity of the officers was linked to their conquests in the East. This specialization gave rise to a military discourse that distinguished Asiatic warfare from European warfare. The emergence of such a distinct military discourse supported the legal idea that violence in Central Asia was not subjected to the standards of international law. Crucially, no alternative legal standard emerged. In Dirk Walter's words, the Russians and the Central Asian opponents were part of different cultures of violence, which precluded the emergence of mutually accepted legal standards. Just like certain Russian accounts reduced Central Asians to savage barbarians, some Central Asian accounts treated Russians as unworthy infidels. The mutual lack of understanding and trust was exacerbated by ideological, intellectual, religious differences. This is not to say, however, that the disjunction between European laws of war and Central Asian warfare was no more than a mere understanding. Alexander Morrison has debunked the long-standing myth of the man on the spot, that is, the assumption that the Russian conquest was brought about by ambitious generals acting on their own initiative. He has shown that, by contrast, the Russian advances were authorized by the highest authorities. The Asiatic Committee in St. Petersburg united representatives of the Foreign Ministry, the War Ministry, the General Staff, and ultimately sought the approval of the Russian Tsar for any significant campaign. The man who filled the ranks of the Asiatic Committee also devised Russia's policy for the promotion of the laws of war in Europe, with Fyodor Martens and Tsar Alexander II being cases in point. Therefore, the promotion of the laws of war in Europe and the unrestrained violence in Central Asia constituted two sides of the same coin, attesting to Russia's ambition to bolster its civilizational image while colonizing its Asiatic periphery. Before we move on to the first case study, I briefly want to use this Vereshchagin painting to illustrate one feature of the specialized Russian military discourse on Asiatic warfare. We see here Russian troops fighting in a dense, in a close formation, and such close formations had become obsolete in European warfare due to the use of heavy artillery. But it kept its relevance in Central Asia, where Russia faced opponents with limited or no artillery at all. So these close formations were subsequently seen as a feature of Asiatic warfare in the Russian discourse. The first case study focuses on the massacre against the Yomut Turkmen, which involved extreme violence against elderly, women, and children, as illustrated here in a print taken from the eyewitness account of an American journalist. The expedition to subdue Khiva was one of the most elaborate and costly campaigns in Central Asia. Once the Russian troops had made it through the surrounding desert, they faced limited resistance. Only the Yomut Turkmen posed a serious threat to the Russian troops, and they refused to cooperate with the Russians even after the ruler of Khiva had surrendered. As punishment for their resistance, the Russian commander von Kaufmann imposed a high war indemnity on the Turkmens. When the payment was not forthcoming, von Kaufmann ordered his troops to punish the Yomuts. In the ensuing massacre, the Russians pillaged and burned Yomut dwellings and killed the fleeing Turkmen in masses, among them children, women, and elderly. The official military report chose evasive formulations to conceal the massacre, speaking of an attack against, quote, a large caravan consisting of significant number of arbors, cattle, and inhabitants headed for the sands. The report omitted that the carriages carried women, children, and elderly. While mentioning the burning of Turkmen dwellings and supplies, the report passed over the fact that this deprived the Yomuts of their livelihood in the desert. The report also omitted von Kaufmann's order that had ordered, quote, to subject these nomads and their families to total and complete destruction and extermination. Despite Russia's efforts to control the narrative, several international observers commented on the massacre. The American journalist Januarius Aloysius McGahan published an eyewitness account of the massacre. It included blunt descriptions of the indiscriminate violence inflicted on Yomut men, women, and children. Quote, "The soldiers reduced the town to ashes and slaughtered every man, woman, or child they could lay hands on." Yet the issue of legality was of no concern to McGahan. Instead, he assessed the overall conduct of the Russian troops favorably. Quote, "Cases of violence towards women were very rare. And although the Russians here were fighting barbarians who commit all sorts of atrocities upon their prisoners, which fact might have excused a good deal of cruelty on the part of the soldiers, their conduct was infinitely better than that of European troops in European campaigns." Let us have a closer look at this remarkable quote. First, McGahan downplayed the violence against women as exceptional, although von Kaufmann had ordered the systematic annihilation of Yomut families. Second, the barbarian nature of the Turkmen was seen to justify violent excesses, capitalizing on the idea that non-European actors did not deserve the safeguards of the laws of war. Finally, McGahan hailed the Russian conduct as surpassing the standards of European civilization, in spite of the heavy civilian casualties. This indicated that the example of European warfare could be activated to praise the Russian conduct, but not as a legal standard to criticize it. In sum, McGahan's account suggested that Russia was acting with just about the necessary amount of violence to civilize Central Asia. Eugene Schuyler, diplomat in Russia, used his extensive network to collect sources and eyewitness accounts of the massacre. He described the indemnity imposed on the Turkmens as a mere pretext to wreak havoc. He discussed von Kaufmann's genocidal orders at length, making the Russian plot for the, quote, "final extermination of the disobedient tribe publicly known." One of his eyewitness accounts supported this conclusion. Quote, "This expedition does not spare either sex or age, kill all of them." Schuyler did not use the language of international law, but his report suggested that Russia might be, after all, not the peaceful and civilizing power it professed to be. Mikhail Terentiev, a former general and a Russian historian, understood very well that Schuyler's report threatened Russia's civilizational standing. Unsurprisingly then, Terentiev sought to vindicate the massacre as, quote, "the most humane act ever committed," since it liquidated a militant and predatory tribe. Although the massacre against the Yomut was reported in the international press, statements by lawyers were few and far between. There was no mention of Khiva in the leading journal of the time, the Revue de Droit International, although the journal pursued the aim to foster, as Martti Koskenniemi put it, the increasing influence of humanitarian ideas in the limitation of warfare and in the conduct of hostilities. As a result of the disjunction between Europe and the non-European periphery, the violence against the Yomuts remained out of sight of international law. Martens took up the issue only in 1879, that is, about 6 years after the event. For Martens, the conquest of Khiva was, quote, "indispensable in order to prevent the recurrence of disturbance in the country and to establish such a state of things as would secure the Russian possessions from the inroads and depredations of the Khivans and the Turkmens." The freeing of slaves served as an additional justification. Martens boasted the abolition of slavery as a major success on Russia's record as a civilizing power. Quote, "If, through the complete subjugation of the Khanate of Khiva, Russia had only secured one thing, namely the execution of the abolition of slavery, she would have earned the gratitude of humanity and acquired a right to recognition from the entire civilized world." Martens compared Russia to England, quote, "a nation which has made immense sacrifices for the abolition of Negro slavery." Ingeniously, this analogy made Russia more European by assimilating it to England, and simultaneously defined the slave-holding Central Asian polities as the common enemy of civilization. In his sweeping justification, Martens passed over the massacre against the Yomuts. Since this part of the campaign had generated much public attention and outcry, both in Russia and abroad, the omission appears deliberate. Even where Martens admitted, quote, "abuses of brute force and reprehensible deeds by the colonizing powers," he promptly reversed the roles by insinuating Oriental perfidy as the true cause for the excesses. Quote, "These abuses on the part of European diplomacy are too often provoked by the craft, double-dealing, and perfidy of semi-barbarous nations." Martens, like his peers, ignored the fate of the Yomuts, although the killing of civilians struck at the core of the formerly inapplicable, laws of war he promoted in Europe. This illustrates the disjunction between the European international law and Russia's conduct in Central Asia, facilitated by an understanding of the laws of war and a deeply ingrained orientalizing dichotomy that placed Russia among the civilized European powers and opposed it to the barbarian savages of the rest of the world. We move on to the second case study. This Vereshchagin painting does not show the capture of Akhal-Teke. It's an earlier campaign, but it brings up the question that we will address in this section. What happens to the civilian population when the Russian army enters a fortress in a city after a heavy months-long siege? By the late 1870s, only the Turkmens on the southern frontier with Persia and Afghanistan escaped Russian control in the region. The Turkmen were organized in tribe-like communities that were incompatible with Europe's state-centered understanding of international law. As a result, they were not recognized as subjects of international law. Their nomadic lifestyle, which involved the capturing of slaves and livestock, posed a threat to the establishment of strict territorial borders and the fostering of trade and commerce. In other words, their way of life questioned essential pillars of Russia's civilizing mission. Previous attempts to subdue the Akhal-Teke had ended in humiliating failure. In 1879, a Russian force retreated with heavy losses from the Turkmen fortress of Göktepe, which exacerbated Russian fears of a loss of prestige in the region. In the eyes of Russia's military men, redemption was sorely needed to reinstate Russia's standing and respect for Russia among its Central Asian opponents. The 1881 campaign, led by Mikhail Skobeliev, was a very elaborate undertaking, with the budget doubled in comparison to the previous campaign. After reaching the Turkmen stronghold of Göktepe in December 1880, the Russians besieged the fortress for over a month. A network of trenches and the use of mines and heavy artillery allowed the Russians to penetrate the fortifications against fierce resistance. The subsequent persecution of the fleeing Turkmen who had gathered their families and belongings in the fortress saw, in Ian Campbell's words, a level of violence without precedent in the previous decades of the conquest of Central Asia. The official report bluntly stated that the Russians, quote, killed up to 8,000 people of both sexes. The massacre against the Akhal-Teke struck at core provisions of the laws of war that were being codified under Russian auspices in Europe at the time. Although they were held to be inapplicable outside of Europe, it is worth spelling out the discrepancy between the progressive legal reform in Europe and the military action in Central Asia. Article 18 of the Brussels Declaration prohibited the pillaging of captured cities. Article 13 banned the killing of, quote, an enemy who, having laid down his arms or having no longer means of defense, has surrendered. Article 39 protected the family honor, religious freedom, and property rights of civilians. The Russian conduct in Göktepe fundamentally disregarded the distinction between combatants and civilians, an essential pillar of the laws of war. The glaring discrepancy was of little concern to Mikhail Skobeliev, who orchestrated the campaign. When questioned about the massacre by a British journalist, he acknowledged that extreme violence was part of his strategy for Central Asian warfare. Quote, I hold it as a principle that in Asia the duration of peace is in direct proportion to the slaughter you inflict on the enemy. The harder you hit, the longer they will be quiet afterwards. We killed nearly 20,000 Turkmens at Göktepe. The survivors will not soon forget the lesson. Skobeliev added that he knew that he would be called, quote, a barbarian by the Peace Society for such a remark, which illustrates his awareness of the discrepancy between humanitarian discourses in Europe and the excessive violence in Central Asia. Thus, Russian generals engaged in brutal fighting in the colonial periphery in full awareness of the humanitarian efforts of the European peace conferences. Skobeliev's principle of extreme violence pertained only to conflicts in Asia, which brings us back to the above-mentioned Russian military discourse on Asiatic warfare. Alex Marshall has outlined how Russian generals arrived at the conclusion that, quote, Asiatic warfare demanded special techniques. This military discourse included, among other things, deliberations on the effect of, quote, awe-inspiring displays of military force. Ian Campbell has suggested theorizing excessive violence as pedagogic killings. That is, quote, violence that would teach resistors not to mount further challenges to colonial rule. The Russian doctrine of Asiatic warfare resembled strategies that emerged in other European countries from the confrontation with the non-European world. Kim Wagner has outlined the British approach to savage warfare, and Dirk Walter has fleshed out the shared features of Europe's imperial wars. Yet, there was a specifically Russian aspect to Asiatic warfare, because Russian officers linked the massacre of the Akhal-Teke in 1881 to the previous massacre against the Yomuts in 1873, which in turn was seen as a reiteration of the genocide against the Circassians in the Caucasus in the 1860s. Thus, the Russian record of previous massacres informed future colonial violence. Since the Eurocentric regulation of warfare suggested that legal restraints did not apply to extra-European conflicts, the notion of Asiatic warfare could endorse massacres and atrocities against civilians at no legal cost. When confronted with the Akhal-Teke massacre, Leonid Sobolev, the head of the General Staff's Asiatic Department, bluntly stated that he, quote, did not see anything in Skobolev's slaughter of the 8,000 Turkmens after the capture of Göktepe to provoke criticism. He dismissed the idea that violence in Central Asia needed to be justified in the first place, which may explain the scarcity of legal commentary on the massacre. Martens, for example, presented the attack merely as a self-evident necessity. Quote, the situation in Central Asia forced Russia to undertake a new military expedition against the Turkmen. This is all Russia's foremost advocate of humanitarianism in Europe had to say about a massacre in Central Asia. I move on to the conclusions, and I hope the timing is okay so far. The exclusion of non-European actors from the laws of war was a joint European project. As a result, Russia faced little international pressure to offer legal justifications for its conduct in Central Asia. The historian Terentiev summed up how this logic of legal exclusion applied to Russia's opponents in Central Asia. Quote, the Turkmen are a dark spot on the globe, a disgrace to humanity. If slave traders are placed outside the laws of all nations, then the Turkmen should be placed in the same position. This logic of exclusion allows us to understand the lack of legal scrutiny of the use of violence in Central Asia. When journalists and diplomats pressed the issue of the massacres in Central Asia, they appealed to moral rather than legal standards. Although there was a certain sentiment that the killing of civilians was reprehensible irrespective of the formal inapplicability of the European laws of war, this did not motivate international lawyers to address the excessive violence. In certain conflicts with non-European powers, like the Russo-Turkish War in 1877 and 78, Russia voluntarily opted to adhere to the formally inapplicable laws of war to showcase its progressive stance, but no such orders were issued for the Central Asian campaigns. In other words, Central Asia remained essentially out of sight of the laws of war. Due to the intellectual and legal disjunction between the European laws of war and extra-European conflicts, Russia's promotion of international law in Europe and its use of extreme violence in Central Asia did not amount to a contradiction. The belief in the superiority of European civilization was widely shared among journalists, military officers, politicians, diplomats, and scholars, and consequently, the onus on Russia to justify its conduct in Central Asia in legal terms remained minimal. The life of Fyodor Martens, whom I've mentioned several times, can serve as a striking illustration of the workings of the disjunction between European international law and Asiatic warfare. Martens was nominated for the Nobel Peace Prize several times in recognition of his contribution to the laws of war, although he also offered sweeping justifications for excessive violence and atrocities in Central Asia. Just like its foremost international lawyer, Russia enjoyed the prestige flowing from the promotion of international law in Europe while employing excessive and legally unrestrained violence in Central Asia. The fact that the Russians, as the alleged harbingers of law and civilization, here again exemplified by the bright and proper Prince Yevgeny, could employ unrestrained violence in Central Asia speaks to the potency of the deeply ingrained disjunction between European laws and colonial warfare. Many thanks for your attention, and I look forward to your comments, Svetlana, and then the general debate.
Wonderful. Thank you so much, Jonas, for this rich and fascinating talk. We'll now pass the microphone to Svetlana Gorshinina.
Thank you very much for this invitation. It was absolutely wonderful paper. It's very, very interesting. And now I switch to the Russian. I think it's could be better for explanation of some things. Мне действительно показалось, что это очень интересный подход, потому что у нас уже есть изучение права. Это и исследования, в частности, Паула Сартори, Ульфата Абдурасулова, но главным образом они основаны на изучении трансформации адата и шариата, их адаптации к российскому законодательству. У нас много исследований о жестокости в разных колониальных ситуациях, и, в частности, жестокости, которая анализируется на основе фотографий. Есть, конечно, книжка Александра Моррисона «Завоевание», есть небольшая статья, которую я написала о завоевании Геоктепы. Но здесь вот эти все разные подходы, они связаны воедино, и это дает какой-то очень новый интересный аспект. Основной тезис, он довольно простой, но в то же время парадоксальный. Россия выступает главным инициатором введения законов, которые регламентируют проведение военных действий, и Россия способствует организации международных встреч, разработке законов и их продвижению дальнейшему. И эта деятельность дает ей возможность почувствовать себя поистине европейской гуманной страной и быть равной великим европейским державам. Но эти законы определяют правила ведения войны. Этих правил несколько. В первую очередь, это гуманное отношение к раненым, медперсоналу, разделение комбатантов, гражданских лиц и следующее. И помимо этого, эти законы определяют также периметр, к кому эти правила относятся и кто должен этим правилам следовать. И вот в этом втором пункте есть возможность двойного прочтения. С одной стороны, это все цивилизованные страны, которые вступают в бой с армиями, которые поддерживают государство. И второе прочтение – это те страны, которые подписали эти конвенции. Проблема с Центральной Азией, что центральноазиатские образования не входят в этот периметр, не потому что они считаются цивилизованными, то есть ни Бухара, ни Хива, ни Какант, как ханство, а туркмены, это туркменские племена, это вообще недогосударственное образование. И в то же время эти страны, эти государства, эти образования не подписывали никаких конвенций. Соответственно, с ними можно вести азиатскую войну или, как это называли в Европе, небольшие колониальные войны. И вот в этих войнах европейские государства не чувствуют себя связанными абсолютно никакими законами. Насилие в этих войнах оправдано, тем более, что речь идет о цивилизационной миссии, и Россия выступает в первую очередь как сторонница борьбы с рабством, освобождает рабов. И вот этот основной тезис вы прекрасно проиллюстрировали. История принятия законов, роль России и игнорирование этих законов в Центральной Азии на примере двух эпизодов захвата. Это все супер хорошо, но теперь такая небольшая критическая часть. Я просто скажу то, чего мне не хватало, и то, что можно было бы как-то еще дополнительно завернуть, чтобы сделать ваш сюжет еще более интересным и еще более парадоксальным. Во-первых, мне не хватало более четкого исторического контекста. У вас есть только 2 эпизода, может быть, в диссертации их будет больше, связанных с завоеванием Туркестана. Но мне бы хотелось иметь своего рода параллель, где, с одной стороны, выстраивается вот эта история выработки закона, которая начинается как минимум с 1864 года, с подписания Женевской конвенции, и с другой стороны, вот эта вот параллель завоевания Туркестана, которая идет как минимум с 1953 года XIX века. И по сути, было бы интересно посмотреть, как уровень жестокости вот этих завоеваний соотносится с прогрессом в выработке законов, которые регулируют ведение войн. То есть, например, как вы говорите о том, что в Брюссельских соглашениях уже речь идет о запрещении разграбления городов после завоевания. Но эта традиция начинается очень рано в Туркестане во время русского завоевания и продолжается очень долго. В Геоктепе мы это как раз-таки и еще и видим. Небольшой бемоль. Пока вы показывали ваши картинки вот в этом тексте, мне казалось, что как бы роль картинок, она действительно была здесь как картинки. Потому что когда вы показываете картины Верещагина, которые связаны с захватом Самарканда 1968 года, и вы рассказываете о Геоктепе, это, наверное, не совсем правильно с точки зрения интерпретации исторических документов. Потому что Геоктепе дала совершенно удивительный иллюстративный материал, который требует своего анализа. Но надеюсь, что это когда-нибудь сделаю. Потом мне не хватило еще широкого интернационального контекста. Вы говорите в вашей презентации только о России. Вы подчеркиваете важность ее роли. Но мне кажется, что проблема в том, что Россия была не единственной страной, которая обеспокоилась негуманным характером войн. И вот здесь, как мне показалось, во всей этой реконструкции отсутствует самый важный элемент – начальная точка отсчета, которая связана с деятельностью швейцарского гуманиста Анри Дюнана. И Анри Дюнан, он, ну, я не буду повторять все факты, которые все и так знают, он основатель общества Красного Креста. Эта идея у него появилась после битвы в Сольферино в Италии в 1959 году. И он пытался создать вот эти добровольные общества, которые независимо бы от государства помогали бы раненым на поле боя. И сначала был создан Швейцарский комитет помощи раненых, потом был создан Международный комитет помощи раненых, и потом он был переименован в Международный комитет Красного Креста. И вот эта работа, которая уже была проведена Анри Дюноном, она привела к первому договору, который регулировал военные правила. Это Женевская конвенция 1864 года, на французском «Convention de Genève pour amélioration du sort des militaires blessés dans les armées en campagne». И вот этот вот первый договор, он был довольно узкий, то есть там была обязанность гуманного обращения с ранеными и медперсоналом. То, что интересно, этот первый договор подписали всего 12 стран, и России там не было. Россия присоединилась к этому договору только через 3 года. И только через 3 года Россия создает свое собственное общество попечения о раненых и больных войнах. И это общество было очень сильно государственным. Оно находилось под патронажем жены Александра II, императрицы Марии Александровны, и большую роль вот в организации этого общества сыграл Пирогов. То есть, наверное, вот говоря о выработке законов, да, надо учитывать и роль врачей, которые сыграли свою роль в этой истории. И потом к этой конвенции уже присоединились почти все европейские государства, и Османская империя, и Персия. И вот тут дальше есть такая небольшая, может быть, опечатка, скорее всего, и в вашем тексте, и в вашей презентации. Вы говорите об Александре III, который вместе с Мартенсом был вот таким царем-миротворцем, который начинает целый ряд акций, связанных с внедрением этих законов для гуманного ведения войн. Проблема в том, что если исходить из дат, которые вы указываете, 1898 год, то Александр III уже в это время умер. И в другом месте вы пишете об Александре II. Он тоже к этому моменту был мертв. То есть Александр II умер в 1981 году, был убит. Александр III, он умирает уже только в 1994 году, а вот это все мероприятие разворачивается в 1998 году. То есть мне кажется, что надо более внимательно разводить вот эти разные царства. Александра II, Александра III и Николая II который, по сути, выступает таким покровителем, инициатором всех последующих конференций. То есть Гаагские конференции, они проходят при Николае II, при Николае II. То, что еще один момент, который, мне кажется, его важно было бы проговорить, прописать, это то, что вот в эти первые конвенции были привлечены Персия и Османская империя. То есть вот это, и они присутствовали на этих заседаниях. И вот тут просто важно объяснить, каким образом, если мы говорим, что это были только европейские законы, только европейские страны этим занимались, каким образом вдруг там оказались Персия и Османская империя. Ведь ясное дело, что эти все законы разрабатывались в первую очередь к европейскими державами. Россия, Франция, Англия, Австро-Венгрия, Пруссия. И они в первую очередь были адаптированы к их собственным потребностям. То есть все остальные регионы мира, как вы много раз подчеркнули, они относились к так называемому вне цивилизованной системе права, и они были скорее объектами, а не субъектами. И вот Персия и Турция оказались в этой истории, потому что их считали такими полуцивилизованными странами, и это было связано с развитием археологии, когда вдруг выяснилось, что вот эти якобы варварские страны, и Китай в то же время, они имеют великое прошлое, не без скобочек и без кавычек. И вот это как-то иначе подтолкнуло смотреть на эти страны. Эти страны стали восприниматься как такие пороговые государства, полуцивилизационные страны, которые можно было допустить в этот переговорный круг, но на правах исключения. И они добавляли определенную символику, делая как бы все эти переговоры не сугубо европейскими, а якобы мировыми. Но это вот показывало вот эту иерархию, которая установилась в это время. Европейские страны, цивилизованный мир, так полуцивилизованный, и варварские страны, к которым относилась, в частности, Центральная Азия. Почему эти страны еще здесь появились? Мне кажется, что это было связано с политическими интересами России. Потому что Россия взаимодействовала именно с этими двумя странами. С одной стороны, это постоянные войны с турками, где Россия выходила не всегда победительницей, и ей надо было защитить свою армию, своих солдат. С другой стороны, это была Персия, которая была вовлечена вот в это противостояние между Британской Индией, между Британией и между русскими царями. То, что происходило в Геоктепе, это очень интересно, потому что победа Скобелева в Геоктепе, она во многом была обеспечена помощью персидского шаха. Именно в Иране в это время находились продуктовые склады и склады с военной амуницией, которые использовал Скобелев. И именно поэтому Персия была приглашена для подписания вот этих договоров и конвенций. То есть я бы добавила бы вот этот анализ, и я бы добавила, что не только Центральная Азия находилась как объект вот в этой вот законодательном творчестве, как объект цивилизационной миссии, но там же находился и Китай, и Индия, и я бы прописала бы как бы более четко вот этот статус Центральной Азии. И другую бы вещь, которую мне бы хотелось бы подчеркнуть, и, наверное, ее тоже надо подумать, как развить, это связь Мартенса и деятельности Красного Креста. То есть ясное дело, что вот эти пацифистские и гуманистические идеи Мартенса, они были связаны с идеями Денона обязательно. С ним вряд ли он был знаком, потому что когда была принята Женевская конференция, Мартенс был еще очень молодой, ему было 18 лет. То есть он вряд ли там в чем-то участвовал. Но начиная с 70-х, 80-е годы, он очень активно сотрудничает именно со швейцарскими юристами. Он часто бывает в Швейцарии. И вот на этой основе он вырабатывает свои, ну, скажем так, доктрины, свои идеи. Мне кажется, было бы очень интересно посмотреть, как эволюционируют взгляды Мартенса как от таких вот положений, которые вы цитируете, где четко видно разделение на цивилизационный мир и не на цивилизованный мир, появляется вот тот его текст, благодаря которому он стал чрезвычайно известен. Это «La clause de Martens». По-русски это так звучит сейчас. Клаузула, да, клаузула, по-моему, клаузула Мартенса. Donc, cette clause de Martens, она фигурирует в преамбуле Гаагской конвенции 1899 года. И вот в этой вот клозе там уже немножко другие интонации появляются. Этот текст гораздо более широкий, и там уже не просматривается вот этого вот четкого деления на цивилизованный мир и нецивилизованный мир. Речь идет как бы о более общем гуманитарном подходе, гуманном подходе. И речь идет о том, что если даже какой-то конкретный случай не урегулирован юридически, то стороны обязаны руководствоваться принципами гуманности и какого-то такого общественного сознания о том, как можно и не можно себя вести. То есть человечность как бы остается вот мерилом допустимости в войне. Чтобы, наверное, еще бы мне бы хотелось почитать вот ваши диссертации, да, в будущем, мне хотелось бы почитать побольше о действиях Красного Креста в России. То есть эта идея очень быстро стала распространяться, и Красный Крест в России действовал на Кавказе во время Кавказских войн, во время русско-турецкой войны, и он действовал во время войны в Туркестане. В частности, он действовал во время осады Геоктепе. Практически все военные, практически все военно-медицинские учреждения, которые существовали при осаде Геоктепе, это были учреждения Красного Креста. И там же находилась представительница царского дома. Простите, я забыла, как ее зовут, одна из каких-то гран-дюшес очередных. И то есть Красный Крест, он нашел свою почву в России. Но в то же самое время это не была та структура, о которой говорил Дюнан. Потому что Красный Крест в России, он был подчинен русской армии, он был подчинен русскому государству, у него была теснейшая связь с императорским двором, и он никогда не был нейтральным и независимым. То, что я возвращаюсь вот к этой моей первоначальной идее, когда мне казалось бы, что было бы хорошо выстроить вот эту параллельную хронологию для выработки закона и для завоевания Туркестана. То есть вот если мы это все рассматриваем таким образом, что начальная точка – это Женевские соглашения, потом вот эти две встречи в Санкт-Петербурге, в Брюсселе, Брюссельская декларация, и как бы самый главный закон – это Гаагская конвенция 1899 года, которая была обновлена в 1907 году. То есть если мы это все так укладываем в хронологию, то мы видим, что Геоктепе 1881 год, оно появляется, это завоевание появляется после Женевской конвенции, после Брюссельской декларации, то есть когда уже начали говорить о гуманности, о защите раненых, но оно появляется 18 лет до Первой Гаагской конференции. То есть мы находимся в такой вот юридической развилке, когда есть первый стейтмент, и еще нет такого глобального закона. И, то есть, можно Геоктепе судить с разных позиций. С одной позиции не было закона как такового, Гаагские конвенции еще не существовали, были только вот эта Женевская конвенция и декларация Брюссельская. Но в то же время уже были сформулированы вот эти гуманистические идеи, которые никаким образом не распространялись на вот эти туземные народы. И на колониальные войны они полностью выходили из периметра вот этой юриспруденции. При этом, возможно, было бы сказать, что Россия не была самой варварской империей вот в этом контексте. Она была такая же, как и другие. То есть ведение Англии, Франции, вот этих колониальных войн, они тоже были ужасные. Но какой такой парадоксальный поворот можно было бы предложить вот этой теме, да? С одной стороны, можно сказать, что как бы вот гуманная идея набирает силу, но она не имеет никакого отражения на поле боя колониальных войн, которые Россия ведет в Центральной Азии. И в то же время идет трансформация идей у самого Мартенса. И когда у него появляется вот это вот клоза de Martens, то это как бы вот такой Рубикон. То есть мы можем говорить, что был Геоктепе, это вот до периода этой клозы de Martens, и после Геоктепе это уже вот пост, когда Мартенс как бы предлагает новый дискурс, более обширный дискурс гуманности. То есть может быть, это, конечно, любовь к парадоксам, да, но, наверное, вот этот клёз де Мартенс можно использовать как своего рода символ юридической реакции на осознание таких катастроф, которые были в Геоктепе. То, что, наверное, можно было бы еще сказать по поводу Геоктепе.
Excuse me, I'm just going to interrupt. I'm so sorry. You've given us so much to think about, Svetlana.
Yeah.
We really appreciate, and Jonas does too. We have so many questions in the chat that
Yeah.
if you could.
I have only
One
one
more point, perfect. Then we
one
have so
more
many
point
questions
to add.
to.
Yeah.
Thank you.
My point is по поводу журналистов, потому что Скобелев запретил всем журналистам присутствовать во время этой битвы. Журналисты, конечно, были не юристами, но они могли наблюдать и могли рассказывать. То есть вот здесь, видимо, было какое-то осознание со стороны Скобелева. То, что он делает в Геоктепе, это уже не соотносится к каким-то определенным мировым понятиям. И последняя, пожалуй, точка, самая последняя. Когда вы говорите, что Россия до сих пор пользуется уважением, потому что она выработала вот эти гуманные законы поведения в войне, наверное, надо здесь учитывать войну в Украине, которая сильно поубавила уважение к России. Спасибо большое.
Thank you so much, Svetlana. Jonas, you're welcome to respond to any or none of those as you wish. She's given you so much to think about. We do have questions coming from the audience as well, from the participants.
No, thank you very much. There was
Sorry, it's possible to stop the.
Yes, the slideshow. Please close your slideshow so that we can see you.
Thank you.
Wonderful, thanks.
Yes, there was a lot that was very helpful and gives me plenty to work on in the next couple of weeks and maybe months, I'm afraid. Yeah. Let's see. I did boil it down and focus it very much on the few selected campaigns. And as you rightly assumed, there are more case studies in the chapter. So, for example, the uprising in Kokand and then the annexation in 1875. That's another example where we can see, I think, how Russia framed resistance as criminal offenses and not legitimate self-defense of the Central Asian actors. So this is definitely another example I plan to use as a case study. And I fully endorse and agree with your comments about broadening the historical context, both for Russia and then also the international context. Maybe one remark on Martens and the Red Cross. There is, I don't want to lie about the year, quite late in the 19th century, there is a controversy between Martens and Fedozzi, an Italian lawyer, in the Revue de Droit International about the conduct of the Russian Red Cross in Ethiopia. And the Italian lawyer basically says, hey, this is not the Red Cross we are used to from other European countries, from other delegations. This is an undercover operation of the Russian military, because it's the overlap between the Russian military, the Russian state, and the Red Cross committee they send is so big that he says this is basically the Russian army acting abroad undercover. So I think this is a starting point for your comment to explore the history of the Russian Red Cross a bit more. And I think, yeah, I might send you an email and go into more detail about some of the points. I think that might be more efficient than having another 10, 50 minutes of me trying to respond to the rich feedback.
So thank you. Let's move on to some of the questions now. We have one from Letizia Fox-Thomas, who's asking, how much is religion an aligning factor to include the civilized and exclude others as uncivilized? And while you're pondering that, I'll just say that for the participants, you are not able to unmute yourselves. So if you'd like to ask a question, you can either put it in the chat or do what Peter Holquist is doing and raise your virtual hand, and we'll call on you and permit you to unmute yourself then. So Jonas, about the religion as a factor.
Thank you very much. Yeah, excellent question. Earlier in the development of international law, the idea that only Christian nations may participate in this shared endeavor of international is more prominent, but this idea gives way to a more secular understanding of civilization towards the second half of the 19th century. But of course, Christianity still sticks around as the foundation of the features of civilizations that come to be seen as the criteria for achieving the right level of civilization. So Christianity is very much around still later on. And in fact, Martens, in his earlier writings, that's in the 1870s, pushed for Christianity to play a bigger role for the admission of states to international law, which I currently interpret as a way to stress what Russia has in common with Western Europe, Christianity, and oppose it to Muslim societies who lack this understanding of international law. So in short, the response is yes, it is very much a factor. By the end of the 19th century, not so much as an official criterion, but it is still around as something that informs the standard of civilization.
Great. We have a next question asking, did the Russian military behave so brutally because of the unexpected defeat they suffered at the First Battle of Akhal-Teke in 1879? And what were the Russian losses in that first battle?
Yeah, very good question. I will not give you any figures on the losses, but it was a substantial loss to the Russian army, which is not that common in the Central Asian conquest. So quite rare that really a bigger number of Russian soldiers died in the defeat. Alexander Morrison has it very nicely lined up in his chapter on Göktepe, so you can find the numbers, the precise numbers there. As to the reasons of the brutal conduct in Göktepe, the defeat certainly played a role in the urge to restore respect for Russia, to undo the humiliating failure that is definitely present in the correspondence of the officers. It's not quite clear what other factors come in. The cases I chose as case studies today, we are 20, 30 years into the conquest of Central Asia, right? And Alexander Morrison mentioned in one of his talks that as the century progresses, Russia's superiority becomes more and more pronounced. The military dominance becomes stronger and stronger. And as this happens, there are less equal battles and more atrocities, more attacks against civilians, because in part, the Russian generals, they come to Central Asia to make a career, to win awards and medals, but there is no battle happening. The Central Asians, they disperse in the desert, or they hide in this fortress, and there's no open battle. They need to gain medals, and then having some sort of military action, and be it slaughtering civilians, is a way to gain these medals. So this is also seen as one of the motives that may have motivated this brutality.
Wow. Okay. So thank you. So another question from Peter Rutland is Vereshchagin's painting Varvary of 1873, is that a reliable source on how the Russian infantry would have formed on the battlefield? He says, presumably they would have been exposed to rifle fire from the Turkmen warriors, even if they did not have field artillery.
Yes. Well, I include the caveat that I'm no specialist of the paintings. I will say, though, that in the reports, we find a lot of instances where the gunfire, the rifle fire from the Central Asian is hugely ineffective. So even a closed Russian formation that is being targeted by the Turkmen soldiers with rifles, not a single Russian soldier dies, or maybe one out of a whole batch. So the low level of the rifles, the low quality of the weapons plays a big role that the Russians can act in this manner, although the other side has firearms, but only in a very basic and limited sense. But I mean, I should caveat this again. It's tricky to use these paintings as a solid source. So the answer is no, actually. Yeah.
Mhm. Okay, although he was present, right? He was there. He was so. On to Peter Holquist, who's raised his hand. Sasha, if you could unmute. Yes, so I think that you can unmute yourself, right? Peter, can you able to unmute yourself?
Yeah,
Yes.
There we go. Can you hear me?
Yes.
Good. Thank you, Jonas and Svetlana, for this presentation, which was really enlightening. And thank you to the 19B organizers. I always benefit from these conversations. Jonas, a thought. There's a lot of similarity between the 1874 Brussels Conference and 1899 Hague. In effect, the Hague Convention on Land Warfare is more or less a transposition of the unratified Brussels Code. But I think for the argument that you're making, it might be worthwhile to highlight the difference in format between the two, because 1874 is a gathering entirely of European powers. They consciously exclude South American states from attending. The U.S. is invited, but declines to participate. Whereas in 1899 at Hague, and this gets to these questions of what is civilized, is religion involved, is a global gathering. And you have the Ottomans, the Persians, the Japanese, the Siamese, all of the South American states. And I think this speaks to what the exclusionary factor is. It's not so much Christianity or increasingly European. It's the presence of state sovereignty, which is exclusive in its own right and is also a European attribute. And I think that presence is very, very telling if you compare and contrast the participants who played. That is, what is key here is not whether you're European and Christian, not even if you're civilized, but whether you have a state and can be recognized in that way. One term I think that you might use more is customs of war. In fact, almost all the conventions say this is a code or convention on the laws and customs of war, because the advocates of codification understood law as only the ratification of what's already existing customs and practices. And that then will explain their belief about reciprocity, whether you are practicing a common set of norms or not. I mean, that is what undergirds, I think, their ideas of law. A question to you. You use the term unrestrained violence several times. And I'm just wondering how you're understanding that, because the violence that you see can be unrestrained or it can be directed and targeted. So Isabel Hull, in terms of the German military in Africa and in the Boer War, argues it's very targeted. As you point out, Ian Campbell has argued for pedagogic uses of violence. So is this unrestrained violence, or is this directed and targeted violence? And I'm just wondering about how analogous this is to other cases. So you brought up the Caucasus. I mean, it's much of what goes on in the final campaign between 1860 and 64 to drive out the Cherkess is a directed form of state violence bordering on ethnic cleansing that is pursued instrumentally and seems very similar to what you see in Central Asia. So I guess I'm wondering how transferable or portable are these practices. Learned a lot. Thank you very much.
Thank you very much, Peter, both for the comments and the questions. I think the comments are homework for me to take care of later, but let me try to address the question. The first one about terminology. Perhaps I use the term unrestrained violence a bit too lightly. What I mean, in fact, and sometimes I think it was in the paper as well, is legally unrestrained. So violence that does not take any legal limits into consideration. And I understand that unrestrained could also mean directed at anyone that appears in front of the Russian army. That would certainly be not correct for what we are talking about here in Central Asia. So that's a good reminder to be more careful about the terminology. Then the second question is about the Cherkessi, the Circassians, and the Caucasus. There's one very interesting moment when the soldiers in the Central Asian campaigns discuss how they will act in the massacres against the Yomut Turkmen and later against the Akhal-Teke. And one of the generals, according to the eyewitness account of McGahan, says, "Let's act in the Circassian manner," which in my understanding, and these are because of the way the military setup worked in Turkestan, these troops come from Transcaspia. So they have experience of fighting in the Caucasus. It's the same people that oversaw the acting against the Circassians in the Caucasus. And to them, it is a reminder to act in the same fashion as in the Caucasus. So I think there is definitely a clear connection between the two cases.
Okay, great. I am sorry, I was muted there. Thank you so much for that question and comment, Peter. We have another question in the chat from Richard Schmidt asking, what do you think about the applicability of Benjamin Hopkins' concept of frontier governmentality for the case of the Russian conquest of Central Asia, through which he conceptualized the frontier as a space where law disaggregates into colonial subjects and imperial objects, with the latter being under imperial hegemony, but outside colonial law, like the Yomuts in this case?
Thank you very much. I must confess that I'm not familiar with the concept, so I will go and look it up and see whether I can put it to use. As far as I can tell from the question, it does seem to... Yeah, at first glance, I think it makes good sense because the Turkmen are a very tricky case since they move around a lot and they don't have a permanent place of residence. So unlike the city dwellers in Samarkand who become Russian imperial subjects of some kind, the nomadic Turkmen are much harder to classify, and they're ongoing disputes between the Russians and then Persia and Afghanistan and China also about whose citizens these nomads are. So that, I think, if I understood it correctly, could be a good indication that there is some sort of frontier governmentality happening.
Okay, thank you. Does anyone have any follow-up questions to what we've heard so far? Or any other questions? You can put up your hand, your virtual hand, or put something in the chat. Otherwise, Jonas, do you have any questions for us?
I'm afraid no. I think I have so many things to work on, so it's hard to come up with additional questions at the moment. But yeah, thank you so much for the rich feedback and many inspiring things I can look into in the next weeks.
Yes. Anne, did you want to add something? If you
Yes,
unmute,
but
yeah.
it's just a comment really and a compliment, and that is that I really think this is going to be useful to people who are working on the category of Blackness in Russia and racialization, particularly Blackness, right? If you know, which is just starting to be kind of articulated, not just race, but specifically Blackness. So I've already sent the reference to a couple people I know who are working on this, and I just wanted to thank you.
Thank you very much. Yeah, I do remember there was a talk on the topic, right? I think a black servant or black woman
Yes,
in Russia.
yes, that was a while ago, right? But yeah,
Also,
there are a few people.
why I thought this could be a good fit to also
Yeah,
give the series a certain kind of continuity. So thank you very much.
yeah, thank you.
Yeah, we also have a further comment from Peter Rutland adding, interesting to compare with the French experience in Algeria, and gives a reference to Douglas Porch, French colonial warfare in Peter Parrott's Makers of Modern Strategy.
Thank you very much.
1981. So this, you'll receive the chat later on, Jonas, if this is not something that's already in your bibliography. So okay, so I think we're going to then wrap up, but many, many thanks to you for this fascinating talk. It was very interesting for people from all different disciplines, very rich for us. And Svetlana, thank you so much for your comments. You gave Jonas and also the rest of us so much to think about. Thank you very much, both of you, for participating, and thank you everyone for coming.
Thank you so much.
See you in December. Thank you for
Thank you.
coming.
Thank you. Bye.
Bye.